Article 11, Section 18 of Tennessee's Constitution contains a provision that says, quote, "Any policy or law or judicial interpretation purporting to define marriage as anything other than the historical institution and legal contract between one man and one woman is contrary to the public policy of this state and shall be void and unenforceable in Tennessee." After the Obergefell decision, the federal district court that had authority over the marriage lawsuit filed against the state of Tennessee ruled that the Obergefell decision did not apply to the provisions of the Tennessee Constitution governing the state marriage licensing laws. Let me say that again and put it in another way. After the Obergefell decision, the federal district court was asked by same-sex couples to enjoin or not allow the state to enforce that provision in the Tennessee Constitution to the extent it applied to Tennessee's marriage licensing statute. And the court refused. No court has ever held that provision unenforceable with respect to Tennessee's marriage licensing statutes. Nevertheless, those who believe in judicial supremacy believe that the governor, legislature, and all state and local officials should ignore that provision in Tennessee's Constitution anyway. However, FACT and others believe that until the Supreme Court holds that states are required by the U.S. Constitution to license marriages, and that the only way to marry in our country is by means of a government-issued license, only then would that provision in Tennessee's Constitution violate the holding in Obergefell regarding licensed marriages. FACT and others point to another U.S. Supreme Court decision, Meister versus Moore, in which the court said that a man and woman could marry at common law, and their right to do so existed before civil governments ever started licensing marriages. The Supreme Court said the right of a man and woman to marry was not conferred on a man and woman by the government. FACT and others agree with Meister. Marriage between a man and a woman would not cease to exist if the states didn't provide licenses. So FACT believes that so long as the U.S. Supreme Court has acknowledged that a man and a woman can enter into a marital relationship under the common law, the legislature should repeal the license law and enact a new law that simply allows the man and woman to file a record with the county clerk stating to the public that they have married. Doing this would not violate the Tennessee Constitution, and it would not violate Obergefell's holding because the government is not conferring any right to marry on anyone. Do you agree with FACT and others that we should not ignore this provision in our state constitution, but that the legislature should repeal the license law and allow a man and a woman to marry and record the fact of their marriage with the county clerk?